Vernon Williams, the second.
All right. Okay, what are we doing on this case today?
Your Honor, I've had an opportunity to talk to Mr. Williams, and there are a few things. First, he would like to represent himself, but he has no problem with me staying on to assist him.
This is where courtroom drama meets real legal limits. What starts as a routine hearing quickly turns into a high-stakes question of competency, self-representation, and control. Pay close attention, because when a defendant wants to represent himself, the law doesn't just listen, it evaluates.
I also think that he needs to be referred for competency and criminal responsibility.
Your Honor,
So you believe that there should be a referral?
Yes, Your Honor.
Your Honor, I have indicated that there has been a referral and that this obviously would be an independent and an additional second referral for competency and criminal responsibility. There was a finding of competency May 26th. I know that when Mr. Feaster was previously counseled, there was some consideration based on some statements on the record. And Mr. Williams claims that he would like to proceed self-representation, that they may pursue an additional referral. And then Mr. Williams did refuse to participate in the criminal responsibility evaluation as well. I have nothing to provide the court to really object on the record to preserve, this record for appeal. So I'll defer to Your Honor.
And
Your Honor, to please the court, may I speak to the court?
Not right this second. Just hold one moment, Mr. Williams. I know you'll get in what you need to get in. Miss Woodson?
Yes, Your Honor.
Have you begun the process of an IME?
No, I haven't, Your Honor. I do have someone I would like to contact to conduct the IME.
And so that typically is being done through, I think, the Office of Managed Assigned Counsel. So you have not begun that part of the process, although you may have a name.
No, Your Honor. I was going to just have him referred. It wasn't until I was speaking with sister counsel yesterday that I found out that he had been previously been referred. So yes, I will begin the process of.
Yes, gotcha. Okay. All right, Mr. Williams. What do you?
Yes, Your Honor. I want to bring to the court that I wish taking stand full purpose honor. I do not wish an assistant in any behalf unless it's going to be Jesus Christ, because God has to go forth and stand as my own attorney, and he has made it plain unto me that he will give me what to say before the court. So therefore, I wish to go before the court, pro persona, my own defense. I do not wish anyone to represent me as a co-defendant attorney. So the young lady, she was incorrect. I tried to correct that when she made that statement. I do not wish her help unless it's Jesus Christ. Otherwise, I don't need her help on this matter. I am going forward before myself, on behalf of myself. And I wish the court would take and get an order to the Washington County administration to get me before the court in my body before the court to take and find a motion for an evidentiary hearing. That's the first thing I want to do, is get an evidentiary hearing. I've been trying to also get before the court a motion, you understand, for the discovery. I have yet to get a copy of the motion for discovery before the court. They told me I should send that to the Attorney General. So I sent it to the prosecuting attorney here in Washington. Then they took and sent it back to me and told me it should go to the Attorney General. So that needs to be corrected, and I will get a copy to the Attorney General for a motion for discovery, because I would like to get that motion for discovery to start, you understand, making preparation for my defense. I am going to stand pro persona before me, before the court, and I want to be in the courtroom. So if you ever want to hear my voice again or see my face again, get an order for me to be before the court. Thank you. The peace of God be with you and your family. Have a blessed day. Thank you.
All right.
Well, okay.
Oh, he was done.
That's probably just as well, Your Honor.
I guess he finished his speech.
And Your Honor, we've gone through this so many times already on the record before. Ms. Wilson came in and you told him anything he needed to file. He's needed to file with me. He's never filed anything with me. And so obviously the second referral is probably well thought through at this point, at least to make sure that we're proceeding in the way that we need to proceed. So
all right.
I will say that as far as if the court does make certain determinations, you did indicate you would keep this, if this does proceed to exam, you would keep this.
Yeah, but I'm thinking about that again, but go ahead. Yeah.
And I would ask that Sister Counsel, I mean, whatever he ends up determining, there are multiple witnesses here that are alleged victims of Mr. Williams, violent victims of Mr. Williams. And so I am going to be asking whatever determinations the court makes, that Sister Counsel be the one to question those particular witnesses. There is an abundance of case law on that matter. And so obviously we need to get through the first step on this. I did make sure I sent Ms. Woodson the original competency report yesterday, so she has that, and we'll go from there.
All right. First thing is regarding the IME. As I listened to the defendant today and his basis for wanting to represent himself, although I don't think he needs a basis, but as I listened to it, the court has some concerns, and this court has concerns as to whether or not he is even in a position at this point to be able to make such a decision. And so I would need to have, or at least see the result of that IME prior to that determination being made as to whether or not he could even represent himself in this case, or making a decision on that, because I don't think his argument regarding that was very cogent, at least from the court standpoint. So what I will do at this point, Woodson, you are going to begin that process.
Yes, I was going to ask if the court would consider a re-referral, but if I think an IME might be a little faster. I know he's been detained for quite some time.
Okay.
Yeah.
Well, yeah. All right. So give me 60 days out. So on the belief, and I think it would be something that you should do in terms of the IME, I just set, you said the 20th?
Yes.
I'll set a competency hearing, another competency hearing for November 20th, 2022. October 20th, 60 days out? Okay, it's only October, 60 days out. I'm already in September. October 20th.
That's good.
2022. Yes.
Thank you, Your Honor.
Along at that time, and his bond will continue as denied, and then I'm just going to defer any other rulings until we can get a grasp on that issue, because I don't think it makes any sense to rule on anything at this point. All right.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Octavia Lewis.
Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Regina Garrett Killer on behalf of Ms. Lewis. Ms. Lewis, can you state your name for the court?
Octavia Melissa Alexia Albertine Lewis, Brianna Alexandria Washington Smith.
Ready then. All right, what are we doing?
And good morning, Your Honor. This is the date and time set for a probable cause conference. If you could confirm, and it's because there's something different listed in the court system that I saw yesterday versus what's listed at jail as to what her actual bond amount is. I believe they tried to straighten it out last night, but I just want to confirm it, and then that may dictate.
I have a 10,000, 10%.
Okay, because in the court system, it was 1,000, 10%.
It says 1,000. I'm looking at the form right here. It says 10,000, 10%, signed by Judge Fink or Magistrate Fink on the 17th.
Yeah.
So there's been some confusion as to what her jail amount or what her bail amount was.
I did have a bond hearing and the bond that was $10,000 10% got reduced to 1,000, 10%. In
When was
December.
that?
Yes.
When
in
was that?
December. Back in December,
Okay.
on the same page.
Okay, so this, you see 817.
Yeah, the 10,000.
Just quiet, Miss Lewis.
That was the original one.
Miss Lewis. What
Ms.
were you
Lewis,
saying?
hang on a minute, okay?
817.
Of 2022. 817, a few days. And what does that say?
10%.
And so the last entry we have in JIS, which I think it's just wrong in JIS, the case management system, says 1,010% for her bond. I'm looking at the court activity record signed by Magistrate Fink, and it indicates 10,000 and the 10% box is checked. So her bond right now is 10,000, 10%.
Okay, and Ms. Lewis, hang on. So in that case, we would be requesting a preliminary exam to be set as soon as possible.
All
Ms.
right,
Lewis-
we also, so that you know, checked the recorder's log of the hearing. The recorder's log indicates 10,000, 10%. So,
But I spoke with Ms. Fink at the time of my arraignment, and I let her know that there was a bond hearing, but she said that the original bond was 10,000, 10%, but at the bond hearing, it was lower. And I have not violated that bond. I just got kicked out of the courtroom at my last court hearing in May. It was not that I was not trying to be in court. It was that the coordinator kept changing the name. And then when I tried to speak with her, she put me out the courtroom. So when I logged back in, they told me that I was too late for my court hearing.
okay.
I was not trying to evade court at all, sir.
Okay, so what are we doing?
So, Your Honor, in the event that Your Honor would entertain a bond motion to lower the amount, we would
I'm not
request that it be
entertaining.
lowered.
I'm not entertaining anything today.
Okay. So, understood. So in that case, I would request that a preliminary exam be set as soon as possible. And hopefully next week, if possible.
No.
Would the people be ready on the 30th?
I can try my best. Is that Zoom or in person?
Zoom would be fine.
No, in person would be better.
Than in person.
If it's in person, Your Honor, I would ask for 2 weeks.
The 6th, yeah. All right.
Right. So Zoom, Octavia, Zoom next week is the fastest we can do it.
Okay.
Okay.
Okay, so what? So
Zoom next week would be requested if Ms. Kirby is willing to do that.
So now we go back to Zoom. Is that right, Ms. Lewis?
I mean, I'm
Okay. I
Yes.
asked these yes or no questions.
I am simply trying to get everything set.
Ms. Lewis, just state, okay, just state yes or no. Are you okay with Zoom next week?
Regina, I'm gonna let you handle that.
Okay, so Zoom next week would be the fastest way, so I vote we go with that. Ms. Kirby, are you okay with that?
August 30th, 2022, 9 a.m. via Zoom and before Judge Fresh Hour.
Thank you, Your Honor. And Octavia, I'll be over to see you, and I do have some additional information from yesterday.
Excuse me, can I ask that again in front of Judge who?
Fresh
Hour.
Who?
Okay, you say that to her. You go right ahead.
I can't hear you.
Let's see where that goes. Judge Fresh Hour.
Fresh Hour, okay.
Yes. Thank you, Your Honor. Thank you, Ms. Kirby and Ms. Lewis.
Thank you.
I will be able to see you.
I don't think I need to know.
For those case, people first. Goodbye.
And that's the tension the courtroom can't ignore when belief, behavior, and legal standards collide. The court isn't deciding guilt today. It's deciding whether this case can even move forward responsibly. Should the judge allow self-representation here? Or was this pause necessary? Drop your take in the comments and stay tuned for the next courtroom breakdown.